Ripple's win in the case against the SEC is getting more and more obvious, and now the case could be officially coming to an end. What will be the next decision? And why could the case end by April? Stay tuned till the end of the video to find out. Welcome back XRP Army. Please like the video, subscribe and comment your thoughts on XRP in the comment section. A letter has been submitted by individual defendants Brad Garlinghouse and Chris Larson in response to the Securities and Exchange Commission's petition for partial reconsideration and clarification in conjunction with the court's DPP ruling. At the beginning of this month, the plaintiff filed the long-awaited motion asking the judge to overrule her own decision ordering the SEC to turn over drafts, notes, and emails relating to Hinmans' 2018 speech, which was found not to be protected by deliberative process privilege due to the SEC's assertion that the speech was merely his personal opinion. The SEC is now alleging that the speech was public guidance, which is a legal term. In response to the SEC request, Ripple's counsel stated that the motion was an inappropriate attempt at a do-over simply because it is dissatisfied with the court's order on its prior briefing. There is no pretense here that the demanding standard for reconsideration has been met. According to the Securities and Exchange Commission, as an alternative, it seeks to outline a topic that has been intensively argued for over a year once more, but this time on the basis of a new theory, which is an almost total reversal of the preceding series of events. Ignoring its prior briefing and a sworn declaration it obtained from former Director of Corporation Finance William Hinman, in which the SEC maintained that Mr. Hinman's speech simply expressed the personal views of the speaker, a position the SEC now knows cannot support its privilege claim. The SEC now argues for the first time that Mr. Hinman's speech was the culmination of and reflected a policy process within the Division of Corporation Finance. Mr. Hinman's sworn declaration is in direct conflict with this reversal. By the way, did you know about this? Let us know in the comment section down below. In a similar vein, the SEC presents a brand new 5-page declaration in flagrant violation of the local rules from someone who has no first-hand knowledge of the issues attested to, and does so without seeking permission or offering an apology. The SEC also eventually fails to demonstrate that this court's order of January 13, 2022 was erroneous, despite its best efforts. Due to the fact that the court considered and credited both Mr. Hinman's sworn statements and the SEC representations that the speech expressed Mr. Hinman's personal views, the SEC will be unable to demonstrate that the court failed to consider or credit Mr. Hinman's adduced testimony or the SEC representation that the speech expressed Mr. Hinman's personal views. What's more, the court had already accepted that SEC staff employees had been involved in talks around the speech and had found that such discussions were merely ancillary to real policymaking. Additional argument, which may or may not be incorporated within the SEC self-selected documents, has no impact on the conclusion of the inquiry. According to the DPP, the communications will not be attached since they did not constitute an essential link in a specific consultative process. Since the conversations appear to have focused only on what should be stated in the speech itself, they were, at most, merely peripheral to actual policy formation, the report concluded. Finally, the SEC protean approach to litigating this issue only underscores why the speech drafts and related communications are important and highly relevant for purposes of discovery to which defendants are in any event entitled. Do you agree that Ripple will win this case? If yes, then make sure to like this video. The response to the SEC motion from Ripple has prompted Mr. Jeremy Hogan, a partner at the law firm Hogan & Hogan, to express his appreciation for the well-written brief that dismantles the several discrepancies presented by the SEC in reference to Hinman's speech, and secondly, to express his dissatisfaction with the SEC motion. Wow, I expected Ripple to come out swinging, and this brief did not disappoint. This is the hardest-hitting brief thus far in the litigation, and rightfully so. The SEC has spun itself a tangled web here, and I don't expect the judge to help them out of it. According to Deaton, the brief's Ripple lawyers are professional and very tactful in explaining that if the court were to accept the SEC new theory regarding the speech, that it is the division's opinion, not Hinman's, then the court would be forced to accept that Hinman lied under oath. The fact that Judge Sarah Net Byrne, who has seen all of the documents in camera, will be holding the mediation might work in Ripple's favor, if the case goes to mediation. She knows exactly what is in the emails, etc. And, if I am correct in that the SEC is the problem child here, that could make a big difference. A good mediator can really work miracles sometimes. His best guess is that a settlement will be achieved in April or May, which will be beneficial to the XRP community, according to his comments. Comment, XRP Army, if you believe the case will be settled by April. Whatever occurs after that will determine how things will turn out. In anticipation of a judgment by Magistrate Sarah Net Byrne on the SEC plea for reconsideration, Ripple, XRP holders, and the whole crypto community will be keeping a close eye on the proceedings. As a result, based on his tweets detailing his predictions, the attorney appears to be optimistic about the outcome of that decision as well as the future verdict on the Estabrook notes. It is my judgment that the SEC motion for reconsideration, as well as the judge's finding that the 63 Hinmans speech emails must be made public, will both be denied by the court. As a result, I anticipate that the Estabrook notes relevant to the meeting with Roisman will also need to be given over. According to Joseph Lubin's statements in January, third parties like as officials from Consensus and the VC Working Group were among those who were most likely to have taken notes during their meetings with the Ethereum Foundation. In the long term, this abundance of evidence has the potential to tip the balance in favor of the defendants. Deaton also claimed that a complete victory is within reach, and that the filing of this motion may be important in bringing the SEC to the negotiating table and putting the XRP dispute to a finish. Gary Gensler, been advised Ripple could achieve a complete victory. This makes Judge Net Byrne's reconsideration decision even more significant. Only when and if the SEC is forced to turn over the 63 Hinman speech emails, and possibly other notes, will the SEC come to the table, if then. Jeremy Hogan, a partner at the Hogan & Hogan law firm in Orlando, Florida, an attorney with a favorable attitude toward Ripple's cryptocurrency community, has suggested that a settlement might be achieved as soon as April or May. He feels that Judge Sarah Net Byrne will have a substantial effect on the next round of settlement discussions since she has seen all of the documents in camera and because the Securities and Exchange Commission is the problem child here, in this case. A good mediator has the ability to perform miracles on occasion, says the author. What do you think about the SEC versus Ripple case? Do you think Ripple will really win it by April? Let us know in the comment section. If you want to continue to know about XRP, we have got 2 videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.